Good morning. We're going to be talking about tenants in liquidation, the rights that landlords of commercial premises have got when their tenant goes into liquidation. There are three areas that I want to cover. First of all, I'll have a refresher on landlord and tenant law, just to cover some familiar concepts. Secondly, I'll be looking at what options landlords have got when their tenant is going to go into liquidation or is in liquidation. And thirdly, I'll be looking at what options you have got as liquidator to respond to that threat. So let's start by looking at ownership of land in England and Wales. And title to land comes into two broad categories. There's perpetual titles, which last pretty well forever, and then there's temporally limited titles, which are those which have got a time limit on them. They may be a fixed term or they may be periodic, but at some point they will come to an end. And the perpetual titles are essentially the Crown and freeholders. There are also common holds as well as freeholds, but you very, very rarely come across common holds. So for all practical purposes, it's freeholds that we deal with. The Crown is there because, technically speaking, none of us own any land. It all belongs to Charles. It's all very Game of Thrones, but even if you own a freehold, you are still tenant, meaning the holder of land from the Crown. And there are circumstances in which even a freehold can disappear and can revert back to the Crown. Most common of those is bona vacantia, which can happen when a company is dissolved when it still owns land, which can own either as a freeholder or as a leaseholder. And as well as bona vacantia, there's also escheat, which is like bona vacantia but worse. And the temporally limited titles, these are the leasehold titles, land that is tenanted, and you could be a tenant holding directly from the freeholder, or you could be a subtenant or a sub-under tenant, in which case your immediate landlord are themselves a tenant of another. And the other occupiers of land that you get, I'm just listing there for the sake of completeness, they don't have title, they don't have ownership of land. They would be either licensees, who are people occupying with permission, or trespassers, who are people occupying land without permission. And a licensee is anybody who is in occupation, who is on somebody else's land with their permission. So it could be when you go into a shop or a pub or a restaurant, or when you hire a hotel room or a holiday cottage. In all of those cases, you're not a tenant, you're a licensee, you're there with permission. And that slide just emphasizes that you can be a licensee or a trespasser directly against a freeholder. There doesn't have to be a tenancy in place to grant a license or for somebody to be committing trespass. Commercial leases, I will categorize into three broad types: long leases, short leases, and periodic tenancies. Long leases here I'm arbitrarily defining as being a fixed term of 50 years or more. In actual fact, long leases, when originally granted, tend to be for 99 years, 125 years, or sometimes 999 years. The issue is that once a lease becomes less than about 60 or 70 years in length, it becomes increasingly difficult to raise a mortgage on it. The main feature of long leases that distinguishes them from short leases is that the rent fixed for the lease tends to be very modest, but it is very modest. It is usually described as a ground rent, and it's very much less than the full commercial rent for the land and buildings. And as a result, long leases tend to have a premium value, a capital value. The tenant is likely to have to pay to take on the lease in the first place, and when it comes to assigning the lease, there's a good chance that the incoming tenant will be prepared to pay a premium to get the benefit of that modest rent. And as a result of this premium value, long leases tend to be good security for loans. You're more likely to come across short leases. These are also fixed term leases, and typically they'll be for something like 15 to 25 years. They will be at full market rent. The original tenant will not have paid a premium to the landlord to have the lease granted to them. In fact, it's more common that the landlord will have granted the tenant a concession, typically a rent-free period of perhaps 6 months, perhaps 12 months. The term can vary, but as an incentive to take the lease on in the first place. And short leases tend to have regular rent reviews built into them, so that every 5 years, typically, the rent will be reviewed and will be increased if it's not kept pace with what the equivalent properties nearby are being charged for. And as a result of the high rent and the regular rent reviews, these leases tend to have little premium value. Although they're described as short leases, they are for a fixed term, and unless the tenant and the landlord have agreed that there will be a break clause, a right for the tenant to bring the lease to an early end, the tenant is committed for the full term of the lease, and it is a commitment of that length of time. The third type of lease that you will come across from time to time are periodic tenancies, and these are sometimes granted informally, where somebody will allow a tenant to use their property on the basis of paying quarterly rent, and there won't be any agreed duration of that. It'll just keep going for as long as both parties are happy with the arrangement. Or it may be slightly more formal, in which case it's likely to be a series of short fixed term tenancies of, let's say, 12 months, on the basis that at the end of the tenancy, the tenant can either renew the lease if they want to do so, or vacate according to what they want to do. And it's probably worth mentioning in the context of renewing tenancies that commercial leases normally come with a degree of security of tenure. There's normally a right for the tenant to have a new lease granted to them on similar terms to the existing lease when it comes to an end. But I won't say any more about that, because I'll be going way off topic if I start talking about that. Instead, I'll talk about the usual parties to a lease. And there are always at least two, sometimes more parties to a lease. The parties that you have to have are, of course, the landlord and the tenant. And for most commercial leases, there will also be a guarantor, usually described as the surety in the lease. And it can be more complicated than that. And if the tenant is not the original tenant, but they've bought the lease by way of assignment, or if the tenant has granted subtenants, it can be more complicated to that with the various consents that the landlord will have granted, which will have added parties, not to the lease, but to the arrangement between all of the parties concerned. And of course, in a liquidation, there is very often a guarantor, very often a director, and very often it will be a concern of the director to make sure that the lease is dealt with in a way that means that they aren't called on for their guarantee. And this is just a diagram to show how you can get chains of subleases. In this example, there is a freeholder who has granted a lease to the original tenant, who thus becomes the leaseholder. That tenant has granted a sublease, so that tenant is also the landlord to their subtenant, and here that subtenant has granted a sub-underlease to a subtenant. So the subtenant is themselves the landlord to the subtenant. And the thing is that every sublease has to be for a shorter period of time than the original lease, so that the sublease ends before the original lease does. So typically a sublease will be for the same duration as the original lease, but minus 1 day is how they normally work. And as I mentioned, most commercial leases do not give the tenant the right to give notice and vacate the premises before the lease comes to an end. Some do have a break clause, but in the absence of a break clause, if the tenant needs to move to different premises, their only options are either to wait for the lease to come to an end, or to assign the lease to a new tenant. And let's assume that the tenant here instructs an agent who finds a new tenant, and the new tenant has a director who is willing to stand surety for these particular premises. So the tenant thinks that they've got somebody that they can pass the lease to, somebody who will take over the lease from them when they move out. What they will almost certainly have to do is to ask for permission from the landlord to assign the lease. And what the landlord will do is they will check the alienation clause. I'll say a bit more about alienation clauses later, but the alienation clause is essentially the clause in the lease that sets out what requirements the landlord can ask for if the tenant wants to assign the lease or to sublet it. And having done that, the landlord will ask for information about the new tenant so that they can assess their suitability as a tenant of their property, and will also ask for information about the proposed guarantor so that they can assess that they are actually somebody who is appropriate to be standing guarantee for this particular lease. And assuming that the landlord is content to have the proposed assignee as their new tenant, replacing their existing tenant, and is happy to have their director or whoever it is standing surety for the lease, they will grant consent, but they won't grant consent immediately. They will be likely to ask, in many cases, for a limited guarantee from the tenant. Remember that there's already a contract in place between the landlord and the tenant for the tenant to pay the rent for these premises for perhaps 15 years. So the landlord is entitled to ask the tenant to stand by that covenant to a limited extent, even after the lease has been assigned to the new tenant. The landlord may also ask for the guarantee from the guarantor to continue in a similar way. They will certainly be asking for the new tenant to give covenants to be bound by the lease so that there is a direct contractual commitment from the new tenant to perform the obligations in the lease, and they will be asking for a written guarantee from the new surety again so that they've got the new guarantor contractually bound in. And only once all of that is in place will the consent then formally be granted for the assignment of the lease, and only then will the tenant be able to transfer the lease to the new tenant. So this is why it often takes a long time to assign a lease, because there's a lot that has to be done with a lot of parties in terms of getting the paperwork right to do it. It's something that isn't always possible to do very, very quickly. So let's say a bit about alienation clauses. And say this is the clause in the lease that defines what the landlord's right is to refuse permission to the tenant who wants to assign their lease. And broadly speaking, there are two types of alienation clause. There's one which gives the landlord an absolute right to refuse consent. They can refuse permission for the tenant to assign the lease without explaining why they're doing it, without having any reason to do it. And the more common one is the clause that says that the landlord can refuse to allow the tenant to assign the lease where there is a good reason to do so. And a lot of these limited right alienation clauses also go on to say that the landlord must not delay granting their permission either. They're not allowed to just let the clock run down on this. And landlords are normally willing to agree a limited right to refuse consent rather than insisting on an absolute right to do so, because leases which can be assigned, which give tenants the ability to get themselves off the hook, are more valuable, so they can charge more in rent for those. So that's a quick refresher on landlord and tenant law. Let's now look at what the landlord's options are when their tenant goes into liquidation. There's four things I want to talk about here. Firstly, let's look at it from the landlord's point of view and see what it is that the landlord is going to be thinking about. Then we'll be looking at how the landlord can influence the course of events. And from there, I'll be having a look at the covenants in a typical commercial lease that a landlord is likely to be looking closely at when they've got an insolvent tenant. And then I'll say a bit about how the enforcement procedures that a landlord might use, how those enforcement procedures might work. So let's start by seeing what it is that the landlord might be thinking about. And I've got 5 things down on this list. They might be thinking about how much they are owed, what other security they've got, how easy it might be for them to relet the premises. They'll be looking at what their other plans they might have for the site, and looking at all of those in context, they will have to decide what their objective is. So looking at each of those in turn, the first one, how much are they owed? And it may not be only rent that they are owed, there may also be service charges for maintenance, for insurance, for various other things that may be owed. And those might be expressed in the lease as being payable as rent, which will give the landlord additional options, for example, in the context of forfeiture, if they're described in that way. The landlord will be looking at what other security they have got. So if they're already owed rent arrears, and if they're concerned that now their tenant is going into liquidation, they won't be being paid rent in the future, they'll be looking at whether they've got a decent guarantee from the director or somebody else. They might perhaps have taken a rent deposit from this tenant when the tenant first moved in. And if the tenant who's now going into liquidation was not the original tenant, but took an assignment, then the landlord might be able to make a claim against the previous tenant who assigned the lease to this one. The landlord will be thinking about how easy it might be to relet the premises, whether they would need to drop the rent if they relet it, or whether they might be in the fortunate position for them of being able to charge a new tenant a higher rent. It may be that there have already been discussions with the business for a phoenix, the same business to continue, same directors, new company. The landlord would have to decide whether they'd be happy with that or whether they would prefer to try and relet the premises on the open market to somebody on arm's length terms, or they might possibly already have somebody in mind as being a prospective tenant. And then they may be looking at some other plans for the site. They might decide that actually they want to redevelop the site, or it might be that they think actually this is going to be a good opportunity just to smarten up the building. Let's accept that we don't get any rent for 6 months, and if we do that, it should be much easier to relet at a better rent. And that will then help the landlord to decide what it is they're trying to do, whether their priority is to recover the rent arrears to get that historic income, or whether they're more interested in securing future income, or whether they're perhaps going to take the opportunity to change the business model in some way. So that's what the landlord is likely to be thinking about. What can the landlord actually do about it? What are their options? And there are three main ones I want to talk about. There are others because, of course, the landlord is going to be an unsecured creditor and will have all of the rights that any other unsecured creditor will have. They might even be the biggest unsecured creditor. But the landlord-specific remedies they'll be looking at are whether they can forfeit the lease, in other words, evict the tenant, bring it to an end so that they can re-let the building. Second one is whether they can distrain. That's the old word for it. It's now called CRA, which stands for Commercial Rent Arrears Recovery, but that's basically sending in the bailiffs to uplift everything at the premises and sell them to try and recover the unpaid rent. Or the third one is, of course, that if you're looking at selling the business, you'll have a preferred buyer who may be wanting to take an assignment of the lease, and the landlord will have to think about whether your preferred buyer is the person that they wish to have as their tenant. So you might find that the landlord's preferred tenant is not the person who's made the best offer to you, but may have made an offer that's rather further down your list. And you may have to be pragmatic about that and work on the assumption that if the landlord is going to refuse permission to assign the lease to the buyer who's offered the best price, path of least resistance might be to sell the business to the landlord's preferred option, even if you're not able to realise the assets for as much as you would like. The landlord will be looking at the critical covenants in the lease to see what options they have got. Where rent has not been paid, the lease will give the landlord the right to levy CRA, and almost every lease will give the landlord the right to forfeit the lease, to terminate it. Most commercial leases have a clause in that says that if the tenant goes into liquidation, that itself is a breach of the lease, which allows the landlord to forfeit. That's different from forfeiture for unpaid rent, because the landlord would have to serve a Section 146 notice, which is a default notice in this context, before they could start the forfeiture action. Landlords often look at dilapidations clauses as well. Most commercial leases put the obligation on the tenant to keep the property in good condition, and if the tenant hasn't been doing that, the landlord can serve a notice of dilapidations, which is a list of all of the items of disrepair that they have seen and for which the tenant is responsible. And if those dilapidations are not put right, then the landlord can serve a Section 146 notice and start the forfeiture proceedings. There may be other breaches as well that the landlord identifies if they want to throw the book at the tenant. For example, the tenant might have been using the lease in a way that is different from that permitted by the user clause in the lease, or perhaps the tenant may have made alterations to the premises without getting the necessary consent from the landlord. So let's look at how these enforcement procedures work, and the ones I'm going to be looking at are CRA, which is sending in the bailiffs to collect unpaid rent, forfeiture on the grounds of unpaid rent, forfeiture on other grounds, which works a little bit differently, and the option that the landlord has to refuse consent to an assignment of the property. So for unpaid rent, where the landlord wants to use CRA to send in the bailiffs, it's all regulated by statute. And the key thing is that the landlord has to give, it's nearly 2 weeks advance written warning before they can send in the bailiffs, which if you're quick, maybe enough time to bring forward the decision procedure under the Rule 614 procedure. And once that notice has expired, then the landlord's bailiffs can seize the tenant's possessions. And some landlords actually use this as a way of getting vacant possession on the basis that once they have seized everything that the tenant is using to carry out their business, the business is going to stop, and the lease will then, that will effectively move the tenant out. And if the premises are sublet, the landlord can use CRA as a procedure for compelling the subtenants to pay their rent, not to their immediate landlord, the tenant, but to themselves, to the main landlord. CRA and forfeiture are mutually exclusive. Landlords cannot do both. They have to choose to do one or the other. Because if they carry out CRA, that is effectively affirming the existence of the tenancy, and if they affirm the existence of the tenancy, they cannot bring it to an end. For forfeiture for unpaid rent, the landlord has the right of either using peaceable re-entry, which simply means going in, changing the locks, and putting up a notice to say, we have repossessed, the lease has ended. Or the other procedure the landlord can use to forfeit is court proceedings. This can be very, very quick. Forfeiture for unpaid rent by peaceable re-entry, and landlords, if they're going to do this, will normally do it first thing in the morning when nobody is around, so that when people arrive for work, the locks have already been changed and the lease has already come to an end. If the rent has been paid up to date and the landlord is looking to bring the lease to an end, but for other grounds, they have to start with a Section 146 notice. That's Section 146 of the Law of Property Act 1925, and that's basically a landlord and tenant default notice. And the Section 146 notice has to give the tenant a reasonable time to put things right. Most leases will say that the liquidation itself is a breach of the lease, and the landlord can then serve a Section 146 notice, and arguably that's something that a tenant cannot put right if they've gone into liquidation. They can't put right that particular breach of the lease, so the landlord will always have the right to forfeit. And once they've served the Section 146 notice, waited for it to expire, they can forfeit the lease by peaceable re-entry, or if they aren't feeling brave enough to do that, they can use court proceedings to do so. And I've already mentioned that, of course, the landlord has got the right to refuse the tenant to assign the lease if they think that the proposed purchaser is unsuitable, is not good for the covenants in the lease. And the landlord is likely also to insist on breaches of the lease being put right when they consent to the assignment. Putting right the liquidation may be difficult, and landlords will normally turn a blind eye to that if there's a suitable tenant presenting themselves. But if they want to make it really difficult for a prospective new tenant to come in, if they really want to object to somebody, then they may well serve a schedule of dilapidation so that there's a huge repair bill for any prospective new tenant coming in. So what are your options to respond to this when you're the liquidator? There's basically three plus a couple of odd ones. The main ones I'm going to look at is using administration rather than liquidation. Second one is using a protective court order in the liquidation. Third one is to pay standstill rent payments to the landlord. And then the two other ones that I'm going to mention briefly are using the Protection from Eviction Act, or just to talk about the option of disclaimer very briefly. So the first of those is administration, and where it's appropriate to use administration rather than liquidation, then even the interim moratorium is effective to stop the landlord from forfeiting the lease or to block CRA. And the interim moratorium is the one that's thrown up either by applying to court for an administration order or by the company issuing a notice of intention to appoint administrators. But the thing about administration is it doesn't fundamentally change the landlord's rights. It just means that temporarily the landlord cannot enforce the right to forfeit or the right to send in the bailiffs. But it is only temporary. It'll give you a breathing space, but no more than that. And if you've got a fundamentally hostile landlord, then administration isn't going to sort out that hostility. Second thing that you can do if faced with a hostile landlord in a liquidation is you can get protective court orders. You can certainly block CRA with a court order if you need to do so. And you can probably block forfeiture with a court order. And because you can block CRA with a court order, you normally find that a landlord won't even try to levy CRA once the company has gone into liquidation. When it comes to restraining forfeiture, a court order of this sort converts a CVL into something that's almost like a lightweight administration. But if you're going down that route, you're going to have the same sort of issues about having to pay rent as a liquidation expense, and you will be in somewhat uncharted legal territory. So administration might be better. Standstill rent payments, this is basically negotiating with the landlord. If you need time, for example, if the business needs 2 or 3 weeks to finish off some work in progress and deliver it to customers, or to run a closing down sale, you might find that the landlord is willing to allow that on the basis of the rent for that period of time being paid as an expense of the liquidation. So you need to make sure that the finances work all right. I mentioned the Protection from Eviction Act. I have known directors to use this. It does provide a short-term solution, and the essence of this is that it is a criminal offence to force entry to any premises if someone is in occupation there, and that would be whether you're bailiffs trying to levy CRA or whether you're a landlord trying to forfeit. And this means that if the director moves in with a camp bed and a dog, and has regular supplies brought into them so that they can remain in occupation, that physical occupation itself can be enough to obstruct the landlord from exercising some of the rights they might want to talk about. Disclaimer isn't really terribly relevant in this context because it is more about a technique to assist you in agreeing creditors' claims than it is in dealing with the landlord itself. So we'll talk about that on another day. In fact, probably on the 5th of June, when I'll be talking about agreeing creditors' claims generally. So those are the 3 points that I wanted to talk about this morning, to give you a refresher on landlord and tenant law, to give you a quick rundown of what the landlord's options are when their tenant goes into liquidation, and what options you've got as a liquidator in dealing with a landlord in situations like that. So, are there any questions now? Just have a look to see if I don't see any questions, and I don't see any points raised on the chat. So with that, I shall just move on to remind you of these various dates for your diary. There's the 12th of May, which is our 2nd annual insolvency conference. The venue for that is Christchurch. It'll be an in-person conference all day. We're now accepting bookings for it. Suggest if you haven't booked, you do so this week while we've still got spaces on that. 5th of June, I'll be back here again for the next coffee break briefing on assessing creditors' claims. And then some other dates, I'm speaking at 2 SESCA seminars and 1 conference. That's on the 18th of May, 7th, the 8th of September, and the 5th of October. SESCA are taking bookings for those on their website. So with that, that's the end of this morning's coffee break briefing. Thank you all very much. Goodbye, and I hope to see you on the 12th of May. Thank you very much.